what I want to try to do is step back a little bit and say to people who are going to decide whether to vote to have a constitutional convention or not, discuss for a little bit, well, what are state constitutions? And try to lay a groundwork for what might happen at a state constitutional convention with respect to these unique documents. So as you consider this question, I think one has to, as I said, step back and think, well, what are we dealing with here? And many people think, well, the state constitution, it's just a little miniature version of the United States Constitution. And that's a big mistake. There's a real paradox in this country that state constitutions are what I call low visibility constitutions, and they're pretty obscure to people. Maybe a little more knowledge here in a state like Rhode Island that has a regular look at the state constitution. But the paradox is that people in this country actually know a fair amount about the United States Constitution, but they have no opportunity to influence it in any way. The United States Constitution is completely inaccessible to us as citizens. It's only been amended however many times, 27 times in all these years. It's really unrealistic to think of any textual change in the United States Constitution. Interestingly, state constitutions are low visibility or obscure state constitutions, but yet we as citizens actually do have an opportunity to access state constitutions and have some influence over their content. Exhibit A, what you're talking about here in Rhode Island. So it's a very odd situation. Everybody knows about the federal constitution, but can't do anything about it. Very few people know anything about the state constitution, but they could do something about them. So let me try to describe why, in 5 or 6 points, why state constitutions are really quite different from the United States Constitution and are really not just little versions of that more familiar Constitution. First, and most people don't realize this, the state constitutions predated the United States Constitution. On the East Coast, at the time of the Revolution, the newly independent states rushed to draft their own constitutions. Now, Rhode Island did not do so, but I live and teach in New Jersey. Our state constitution dates from July 2nd, 1776. And there were 4 or 5 other states right away in 1776 with their own constitutions. These then served as the actual models for the United States Constitution 11 years later. Many people don't realize that. The first great distinguishing factor is that the origin or the pedigree of state constitutions is quite different from the United States Constitution. Again, Exhibit A here in Rhode Island. The people vote on the adoption of state constitutions or revisions of state constitutions or amendments to state constitutions, and even on certain policy matters such as gambling, assumption of debt, what have you. None of us ever voted on the United States Constitution. You remember that was submitted to ratifying conventions that made the decision. Even now, amendments, rare as they are submitted to the state legislatures, not to us as voters. So it turns out, actually, the state constitutions are much more democratic than the United States Constitution. And again, we see this played out quite explicitly right here in Rhode Island, as well as a lot of other states. Interestingly, too, the state constitutions reflect, they have the fingerprints of alternative voices. You remember that the United States Constitution was the product of 55 pretty old, pretty white men sitting in Philadelphia. Yes, the 14th Amendment and the post-Civil War amendments did have involvement of African Americans and maybe a few women. I'm not sure about that, Ellen, but the state constitutions do reflect the attitudes of, you just heard 20% of your Constitutional Convention in 1986 was women. Our 1947 Constitutional Convention in New Jersey was 10% women. We've seen African Americans, Hispanics, young people. I think if you have a constitutional convention here, you'll probably see members of the LGBT community, all sorts of voices that I call alternative to what we've seen in the United States Constitution's slow evolution. And you know, this could make a very different sort of reflection of the attitudes of the citizens here and in other states. The second main distinction between state constitutions and the more familiar United States Constitution, the state constitutions are much more flexible, obviously. They're malleable. They have permitted the states to operate their government, their rights, and the matters that they've constitutionalized in a trial and error process that's just simply not available at the federal level. Again, the United States Constitution is for all intents and purposes impossible to amend. So that the states have been able to keep up with changing times, not as well as a lot of people want sometimes, but the states have been able to keep up with changing ideas about governmental institutions, about rights, and again about matters that should be entrenched in the Constitution rather than left to ordinary lawmaking. The state constitutions reflect these matters, such as item veto for governors, which I take it you still don't have here in Rhode Island. 46 or 47 states have that now. That's no one ever thought about that, and almost every sitting president would kill to have the item veto, particularly former governors who reached the presidency after serving in a governorship that has the item veto. Likely impossible at the federal level. Term limits, a more modern idea about the structure of government, have been able to, whether you agree with that or not, they've been able to be inserted into various state constitutions because the state constitutions are able to evolve. Limitations on legislative procedure, the blocking of enactment of laws on multiple subjects, omnibus laws, which we see at the federal level because there's no limit on how Congress can legislate. In the states, we see very substantial limitations on this process. In the rights area, states have adopted equal rights amendments, textual privacy amendments, and all these sorts of things that can actually be done at the state level. Again, virtually impossible at the federal level, as those who worked on the federal ERA came to realize. Third major distinction is that the legal and political function of state constitutions is actually quite different from the legal and political function of the United States Constitution. Again, they're both called constitutions, so most people in our country think, well, there's the big one, and then there's all these 50 little ones that are kind of like wrong. And you remember this from civics, if you think about it. A lot of you already know this, I know. The U.S. Constitution, of course, was drawn up by representatives of the states, and the United States government operates under an enumeration or a grant of fairly specific powers. Now, yes, the United States Supreme Court has expanded on these over the years, but you'll remember that the United States government can regulate interstate commerce. It can provide for the national defense. It can provide for post offices and post roads and some other stuff. And that's it. Remember, everything else was left to the states. And this is even expressed in the 10th Amendment to the U.S. Constitution. So everything else about how government operates is left to the states. So when you think of in Rhode Island, should we pass a landlord-tenant act? Should we pass a land registration statute? Should we pass a criminal code? You don't have to look to your Constitution to see if that's possible. impossible. Where do we get the authority to do that? No, all of this power was left to the states. We call it residual plenary power. So the main legal and political function of the state constitutions is to limit that power. Okay? So this is a little bit of an oversimplified distinction, but it's quite powerful. The major function of the United States Constitution, in terms of government power, certainly there's the Bill of Rights that limits the federal government, but the main function of the federal Constitution is to grant or enumerate fairly specific limited power. The main function of state constitutions is to restrict or limit this plenary, residual, quite broad power. And this really influences judicial interpretation of state constitutions by contrast to the federal Constitution. Remember last year, could the U.S. Congress pass the Affordable Health Care Act? And that was a question about power, enumerated competency, the comparative lawyers call it. And remember, it turned out that U.S. Congress, by a 5-4 vote, was not allowed to do that under the power to regulate interstate commerce. It turned out it was allowed to do it under the taxing power. Big surprise to a lot of us who watched that case. But that was a case about what can the government do. The cases in the states are what can the government not do. Okay, so it's really the other, quite opposite sort of legal and political function. As a result of this, the U.S. Constitution is an incomplete document. It's an incomplete governing document. It doesn't provide for how the states govern themselves, how the states structure their governmental institutions, how the states provide for rights and such. Very little in the U.S. Constitution about how states operate. And if we didn't have the state constitutions to fill in all of those gaps, we wouldn't have a constitutional system in our country. So really, of course, American constitutionalism includes both of these different kinds of constitutions that are quite different from each other. A couple more quick points. The form, what the constitutions look like, is quite different. You know, the revered federal constitution, it's brief, it's endured for all these years, very few amendments. Gosh, isn't this what a constitution should look like? Well, maybe a constitution that grants or enumerates specific powers should look like that. How many words does it take to say that the U.S. government can regulate interstate commerce? Not very many words, it turns out. State constitutions, by contrast, are longer, much longer. The Alabama Constitution is that thick, outrageous, but nobody wants to change it down there. There's more there in state constitutions. More is constitutionalized in the states than in the United States government. And to some extent that makes sense because there's more government authority in the states than there is in the U.S. government. This surprises people because people think of the U.S. government as being so all-powerful. And it is true that when the U.S. government uses its spending power, it can affect all kinds of state matters like education and healthcare and all those sorts of things. But so not only do the state constitutions deal with a much wider range of governmental authority, they also are much easier to amend. Again, Exhibit A, Rhode Island. And as a consequence of that, the state constitutions are layered with the concerns of each generation, or even every several generations. It just depends how often the constitutions are revised or replaced, how long they endure. But they don't endure that long. Louisiana's had 11 state constitutions. In New Jersey, we've only had 3. I'm from Florida originally, maybe we've had 4. How many have we had at the national level? 1. Okay. So you see this reflection in the state constitutions the concerns of the generations that we've seen. Next, okay, the state constitutions are different in origin, function, form, and now as well they're different in quality. They're different in respect to what's in them. Yes, of course, state constitutions structure government institutions just like the U.S. Constitution does. Yes, state constitutions have declarations or bills of rights, not just like, but similar to what the United States Constitution has. But yet they have long articles, and I haven't checked Rhode Island, but most states have long articles on taxation, on education. Out west, water rights, very important. Water's becoming more important than money out west. Environmental provisions, corporate regulation. Notice all of these things could be left to ordinary lawmaking by the legislature. But what we've seen over the 225 years or so in the states is that many of those policy matters have been entrenched in the state constitution over the years. Again, succeeding generations of concerns. Why? Because they don't trust the legislature with respect to any legislators who are here. By the way, I got interested in stuff because after I graduated from Florida State, I worked in the state legislature for the summer before I went to law school, back in the midst of history, 1967. And that summer they rewrote the state constitution. And all of the same kinds of concerns came in, and so I got to see up close that sort of process, and here I am so many years later. But so the state constitutions again have the different qualities because they include all of these policy matters that operate to limit the legislature. As well, we see positive rights, social and welfare rights that are quite different from the U.S. Constitution's negative rights, okay? And I just learned apparently since 1986 you in Rhode Island have a right to libraries. Fantastic. That mandates the legislature to do something with libraries. I don't know what would happen if the legislature didn't do that, but studies have shown that nationally about 40% of what is in state constitutions are policy matters that certainly could be let. You wouldn't need anything in a state constitution dealing with taxation. You wouldn't need any. This is within the reserved plenary authority of the states, primarily the state legislature. You wouldn't need anything about education. You wouldn't need anything about corporations to enable the state legislature to make policy with respect to those matters. But again, that would scare the daylights out of most people. Gambling is another good example. Here in Rhode Island, in our state of New Jersey, legislature's not going to be allowed to deal with gambling. Why? Because of the decisions of these succeeding generations. So again, ease of change leads to a lot of these things. Some people think the state constitutions are too easy to change and therefore are really not constitutional. Some people think that state constitutions are too long, they're too detailed, and therefore they're not really constitutional. And what these people are doing is comparing state constitutions to the model that all of us know, which is the United States Constitution. I want to suggest that's a big mistake. And as you go forward in trying to determine whether to have a convention to look at your state constitution, and if you do have a convention, to look at what functions and qualities the state constitution has by contrast to the U.S. Constitution, that this is the way you'll think about your state constitution. They're real constitutions. They have constitutional authority in our American system, but they're different from the United States Constitution and they ought to be different. So I want to call on my colleague Alan Tarr, from whom I've learned everything I know. I'm sorry, Alan, I forgot one point. I just looked down at my notes, excuse me. What you're going to say, never mind. And I still have a minute. John mentioned this, that state constitution making, the notion that state constitutions can be a tool for policy making, that notion has been discovered by national groups. And we saw it in the example in 1986 of divestiture in South Africa. That's not going to, if you have a constitutional convention now, that's not going to come up. That's history, okay? But what's happened is a lot of the national questions that we think of across the country sprout up in state constitutional change processes. Abortion, the questions about abortion, you know full well the questions about same-sex marriage. These are national questions. Gay rights. Now, more recently, animal rights. In Florida, we have a long provision in the Constitution that says how farmers have to treat pregnant pigs. Okay? I like pregnant pigs, and this is a national movement. It's not just a Florida movement. Countered by hunters, hunting rights, that kind of thing, and fishing rights. Now we've got anti-Islamic law provisions in Oklahoma and other states, anti-international law, trying to limit state courts from relying on those, anti-affirmative action, which tends to be a national issue before the United States Supreme Court now with the Michigan constitutional anti-affirmative action provision. The last election, and then I'll yield the floor. I still think I have a minute. This last go-around, you may have noticed there were a number of amendments proposed in the states that said nobody in our state shall be required to buy health care coverage. This is a national debate, of course. Other provisions, nobody shall be required to vote for a union without a secret ballot. This was an attempt to deal with the pending national legislation it never passed, but on labor rights. So this go around, it's the issues of the day, together with central questions about how your government is structured and such, that will come up in a constitutional convention. So, sorry, Alan.